Well, they're only saying it's about 200 that they paid over the time.
I paid my DTE bill. I paid all the bills that I needed to pay up until this rat infestation was not taken care of. And then they lied about the rat poop, and they didn't.
Okay, but hold on.
Holiday vibes are gone. The judge jumped straight into eviction enforcement. Appeal dismissed, escrow unpaid, and nearly $30,000 hanging in the balance. The defense pleads for more time, but will procedure override sympathy? Subscribe for more dramatic courtroom breakdowns. Like and share this intense legal showdown.
Are you starting up as Monday this way? It's Tuesday. That's why. See? Sorry. That's why I can't give you any time off. I did. Why are you yelling at me? You know, I had a peaceful President's Day, and then court does call the case of Patrick Totora versus Martin Youts and Teresa Youts and all occupants.
Good morning, Your Honor. May it please the court, Eric Ladavsky, 65354 on behalf of plaintiff.
Good morning, Your Honor. Darwin Fair, P number 31266 on behalf of the defendants and all occupants.
All right, this is the plaintiff's motion, correct?
Yes, Your Honor.
All right, go ahead, sir.
Thank you, Your Honor. Your Honor entered an order of eviction on July 1st, 2025. The defendants filed an appeal of that order of eviction. This court then ordered a bond on July 11th. The court amended the bond on September 15th. And then the defendant's appeal was dismissed on January 27, 2026 by the circuit court sitting as the appellate court. Therefore, with no appeal pending, we're asking this court to be able to execute on the order of eviction that this court entered on July 1st, 2025.
Mr. Fair.
Thanks, Your Honor. First of all, thanks for allowing me to appear by Zoom. My clients really appreciate that. With regard to our argument, let me just say this, Your Honor. There's three issues. Number one, the underlying case is actually before the Michigan Court of Appeals. That case has not been decided by the Michigan Court of Appeals by way of delayed application for leave to appeal. So with regards to the underlying case of this matter that's before the court is still pending. Number two, with regards to the Washtenaw County Circuit Court, I have been retained to appeal that case, so we intend to appeal that forthwith. And then number three, with regards to escrow. Judge, let me just say this with regard to escrow. My clients just do not have the financial wherewithal to make escrow payments. And let me explain why. As the court knows, this is a storied case. There have been a number of properties involved, the most important of which have been my clients' actual business in which they derive revenues. That has been turned over to the plaintiff. And so my clients have a huge financial distress as a result of it. And I would also add that that property, the equity in it, is my understanding around $2 million that the plaintiff now has. And with regard to this property that's currently before the court, this is their home. And the equity on that, my understanding is around $2 million. So we're asking, Judge, that two reasons for a stay. Number one, the underlying case in the Wayne County Circuit Court is still pending. And number two, I have been retained to file an appeal of the Washtenaw County Circuit Court. The bottom line is no one knows what these courts are going to do. If they rule in my client's favor, it's going to obviously be a problem for the plaintiffs in this matter. So it just seems to me this last piece of property, which is the home of the defendants, be stayed pending the outcome of the appeals. Thanks, Your Honor.
Any additional response from the plaintiff?
Yes, Your Honor. Regarding the escrow order, this court made it crystal clear in its amended bond dated September 15th. As long as there's an appeal pending, with Mr. Fair's arguing there is an appeal or there's going to be an appeal, the defendant shall post $5,823 per month commencing October 1st. So as we sit here today, they are $29,115 short on escrow. So if this court is going to entertain a stay, I would ask the court to order that if a stay is entered, they must post the $29,115 forthwith and continue that amount.
Well, this court is not inclined to issue the stay. If the defendants wish for a stay in this matter, they can certainly request it of the appellate court for a stay on this. However, to the extent a stay is granted, all back escrow must be paid into this court prior to a stay of the writ. In this case, that will be my rule. And certainly the Court of Appeals or whatever appellate court can overrule that. But if they do issue a stay, then this court believes that all escrow should be paid, as that was a condition of the stay pending appeal, and is consistent with the court rule. I have read the order of the Washtenaw County Circuit Court. Believe it to be in order. They have held that decision. The court will do two things. The $7,500, which is currently in escrow, will be released to the plaintiff. And I am signing as we speak the order of eviction. That order of eviction may issue and may be executed on. So,
Your Honor, if I may, if we're allowed to appeal or ask the Michigan Court of Appeals for a stay, we would need time to do that. We can get that motion out as soon as we file the appeal. So I'd ask the court to stay the eviction until the Michigan Court of Appeals has made a decision on our stay.
absolutely not, Mr. Fair. I'm not going to stay this any longer.
Okay, well, Judge, what about with regards to the 29,000, and I don't have that exact amount, 29,000. Mr. Ledez, how much did you say that is owed in escrow?
$29,115 from October through February for at $5,823 per month.
Okay, and Judge, what if he posts that amount? Then if he posts that amount, he apparently
You
won't
would
be
need to
evicted.
have an appeal pending and that, but I'm not staying my order. So
I understand that, Judge, but we can't get a stay with the Michigan Court of Appeals until the appeal is filed. I intend to file that forthwith.
But you can indicate in your appellate paperwork that this court has denied the stay. And then they can act if they so choose to do so.
Yeah, and I understand, Judge. The only point I'm making is the Court of Appeals, and I've done these before, the Court of Appeals don't give you an answer overnight. I would say, because here's the process. The process is that you ask for appeal bond and you ask for
I understand how, Mr. Fair,
yes.
I understand how the process works. You've done it 5 or 6 times in my court, so I certainly understand it, and I know how it operates. What I am indicating to you is I am not staying the order of eviction. The order of eviction will issue. If you may have an order indicating, or you can indicate to the Court of Appeals that this court has denied the stay, and then you can choose to do so. You can, if they decide to act, if they will act in time for you, then they'll act in time for you. If not, well, this is where it's landed. Okay. I have signed the order releasing escrow, so that won't be an issue. And I also have signed the order of eviction, so that may go forth as soon as it can go forth, unless it's stayed by an appellate court.
Thank you, Your Honor.
Thank
Thanks,
you.
Your Honor.
Pleasant Lake versus Christopher General. I'm going to give that to you. Okay. Sign the order.
Good morning, Your Honor. David Morris on behalf of Pleasant Lake Park.
Good morning.
I'm Christian Obiaki.
What are you trying to hand my bailiff?
I tried to turn this into the clerk, but she's like, "Oh, your time's kind of running out. You should just go in the courtroom." Giving it to you is like the quickest way.
What is it?
It's just a summary of the reality since January 31st till today. I could read it.
The reality of what? Of the household or of life in general?
The reality of this court case, Judge.
Or you have to show it to the plaintiff before I'm going to even begin to look at it. Do you mind?
I don't mind. No, this would be his argument today, and it's just a roadmap to his argument.
Here's where the money math tightens. Security deposit applied, escrow considered, and the gas bill disputed. The judge narrows it down, about $200 in question. Legally, unpaid rent dominates everything. Emotional testimony won't erase statutory deductions. When numbers get specific, courtroom sympathy starts shrinking fast.
All right.
I just have a couple comments that I forgot to put in there.
Sure.
This is my favorite sweatshirt. Like, this has all been eaten by rats. There's here, the sweatshirt underneath has been eaten by rats. I've lost 2 pairs of Michael Jordan tennis shoes that are eaten by rats. These pants are eaten by rats. My really nice pair of Kappa pants that were like fuck, eaten by rats. I removed everything that I could from that house that's rat infested, that's owned by Mr. Weasel. But like, due to my disability, I couldn't move like a couch and table and chairs. But I had to like cut my king size mattress in half. I cut my dresser in half, all with a chainsaw. Took me, and then I cut my mattress with a knife. So like I know he's withholding the deposit. I left a couch in there, but like, I did literally as much as I could, like without taking myself to worse. So.
Good morning, Your Honor. We're on today's final settlement conference. Plaintiff is requesting, last the court acted, Mr. Janowiak was ordered out by January 31st. He did that.
Right.
He vacated the premises on time. Plaintiff was withholding security deposit. We haven't had a forwarding address given to us.
It's a P.O. box because I'm homeless.
But the rent has been withheld for the security deposit has been withheld for unpaid rents, not for damage to the premises. There was some furniture left, and I would say excessive filth and trash, which demanded cleaning, but that hasn't been, we haven't charged for that at present. And so plaintiff,
Don't mean that. How much was the security?
the security deposit was $1,000.
Okay.
The outstanding rent, including the gas bill that was never changed over to his name.
It was changed on the 31st. It was
Sir,
changed.
sir.
Straight
Hold
line.
on. I will let you respond. I always do. But go ahead.
Thank you, Your Honor. The unpaid rent and gas bill is $4,005.19. If Your Honor were to, so if we apply the security deposit, the amount outstanding is $3,005.19. If Your Honor were to disperse the escrow funds, unpaid rents would be $1,770.19. And so that's what plaintiff is asking for today, Your Honor. I can make additional arguments for why I believe there's no trial issue in this case, if that we.
The DTA was taken out on the 30th. Now it's gone by
The 30th of January.
on January, yeah. And then I'll make that is a straight lie. I mean, he also
Hold on. He didn't say that you didn't take it out of your name. I mean, you're not charging for the 14 days, are you?
Correct. So my understanding is that he was required to put the gas into his name, and that either didn't happen or went unpaid, one or the other. So I believe my client's books records show that they were just auto paying the gas over the course of his lease.
That's not.
And how much is the gas of this amount?
We're talking about approximately, I have it broken down by month here, but approximately $200.
That is, I've been paying my DTA every month since I've been there. That's a straight lie. Like, that's a pure lie. Like, swear to God.
Okay,
That's a pure
so
lie.
hang on.
All the records are there. I mean, how can you lie about that?
But hold on. You didn't pay the rent, so
I know I owe DTE like $400. That's it.
well, they're only saying it's about 200 that they paid over the time.
I've paid my DTE bill. I paid all the bills that I needed to pay up until this rat infestation was not taken care of. And then they lied about the rat poop, and they didn't.
Okay, but hold on.
This is a nightmare.
The security deposit can properly be deducted pursuant to statute against back rent. If there's $1,250, I think it is, in escrow. If that's paid over to the plaintiff, they have the $1,000. Your balance with your unpaid rent and the gas bill, but hold on a moment, would come to the $1,770.19. If I were then, and maybe over the objection of plaintiff, but again, I really don't have a tribal issue, and I don't know if plaintiff wants to try it over $200. If I were to give you credit for the $200 gas bill that they're collecting,
That's it. Just $200 over the whole time, not $200 every month. I just have this understanding. I'm sorry.
well, if you had listened to what counsel was saying, that's what he's indicated to me, that it's about $200 that they've paid. So hang on, if I give you credit for the $200, that would bring any judgment amount to $1,570.19. So I give you credit for the gas.
So I'm disabled and homeless. I can't afford to pay anything. I'm barely eating as it is. And I lost my job because of this rat infestation. I worked from home for AAA. There's a full-blown rat infestation in the house. You got my next door neighbor to lie about it. Who is Steve? I mean,
Sir, I've been through that initially. I think
I
it
know.
was badgers. Then I think there was a beaver that came up.
you know,
Then that transformed into mice.
now
And then they became rats.
yeah, it just
And
compounds.
I know all of those rodents running around. I know.
I'm not blowing smoke. I never blow smoke at the judge. I'm blowing.
No, I'm not saying that you're blowing smoke. I'm just saying that's a lot of vermin
It's a lot.
in one spot.
And eating my clothes, eating my food. Look at this. Clothes. My clothes are eaten. I've had to throw away at least $500 in clothes because they're just lying about it. This is an inverted nightmare.
Sir, I don't have anything to try. What you've asked me for, and I've read over what you gave to the court. You want the escrow back. I don't think that's proper because the rent hasn't been paid. Also, in looking at everything in regard to this, I don't see where you would be entitled to any abatement necessarily of any rent in this, or that they're gonna need to pay you damages.
So the damages are my clothes have been gone. I lost my job because the rats were literally underneath my bed. They were nesting. They were nesting inside the dresser, a foot from my house. I mean, a foot from where I lay my bed, where I lay down. I mean, there's a rat's nest literally underneath my bed, inside the house, and they lied about it while we were all standing in rat food. And then this kept going on, and no professionals were hired.
I've listened to you every time you come here. I understand what you're telling me, but just because you keep repeating it doesn't make it true. You would have had to substantiate that, and you haven't. And so all I'm here to do today is we've dealt with the possession issue. Now we're dealing with just the monetary issue. And I don't think there's an issue for me to try regarding the money.
I can't afford it.
Okay, listen.
I swear to God, I can't afford it.
Okay.
I mean, I'm literally on SSDI.
But
homeless.
That may become their issue regarding any amount I give in collection of it.
I mean, I'll have to file for bankruptcy. And then, I mean, that all washes away. If I file for bankruptcy, then
he gets, well, I don't know what the bankruptcy court is.
It's washed. I mean, you are talking to a disabled street kid that was forced out of his home because of rats and lost his job because of rats. While the whole time the landlord is saying, "You're lying. There is no problem." Then I have professionals backing me up. And then I have him saying that, like, oh, he's told other neighbors that he's gonna shoot me. Where is that neighbor? That's defamation. I mean, I know that's like a different court case, and I have to go get a lawyer, blah, 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 blah. I know we're just talking about money today, not defamation. That's a different case. I get it. I'm not dumb. But I mean, like, I've been defamed. I've been put on the street. I have lost my job. I've lost my clothes. I've lost my health. I've lost literally almost everything because Mr. Weasel is not maintaining his property. I mean, I'm repeating myself because I'm just expecting you to slam dunk on these people and pay me and shame these people and wish me well. That's what I thought. I mean, you have a reputation of being the all-star judge in Michigan. I expect you.
I don't know if that's the case.
I mean, I'm just being honest.
My kids think of me that way, but I don't know anybody else.
I mean, I'm not
No,
gonna say
listen, sir, listen. You may have thought you knew what I would do in this case. There are attorneys that come in every day thinking they know what I'm going to do, and then they become greatly surprised. Because what I'm going to do is I'm going to follow the law. I may feel for you. I may have sympathy for what your plight is, but I'm going to follow the law. That's how it works.
That's what I want you to do, is to follow the law.
And that's what I'm going to do. And what I'm going to do is I'm going to find that there's no tribal issue. I am going to give him credit for the $200 gas bill. So I'll award, and also I will not charge him cost. So I will award a total judgment amount of $1,570.19. The escrow will be released to plaintiff. That is the court's ruling. Thank you.
Thank you, Your Honor.
I did write it.
Thanks for your time, Judge.
Thank you, sir. Did he salute you? He did. Mr. Brown.
The judge makes it crystal clear. Law over emotion. Rat allegations aside, unpaid rent and statutory rules control the outcome. Judgment, $1,570.19. Escrow released, no trial needed. Hard reality in landlord-tenant court. Like, comment, and subscribe for more shocking courtroom stories where procedure decides everything.